Our first case for argument today is Johnson against C.R. Bard. Mr. Curtis.
May it please the court, Casey Curtis on behalf of appellants C.R. Bard and Bard Peripheral Vascular. I'd like to reserve 5 minutes rebuttal. In terms of my presentation today, I'd like to cover the three grounds that we've raised in our briefing for why we believe a reversal and remand for a new trial is required in this case. The first being Dr. Hurst's changed testimony that was undisclosed in violations of Rules 26 and 27. The second, the district court's sua sponte reopening of the plaintiff's case in order to allow the treating physician, Dr. Goncharova, to testify. And the third being the district court's decision not to instruct to the jury on the presumption of non-defectiveness that applies under Wisconsin law for compliance with applicable federal or state regulations.
Can I ask you a question right off the bat? It seems very strange to me, beyond strange, that Bard did not in any way put before the district court the possibility of a mistrial, the possibility, clearly stating to the district court that Rule 26 objection that you have. I've looked very carefully at the record citations that you offer for that first point, and at one point you say, well, it's not really our fault, so we should be able to raise this now. But we try to make the trial work as well as possible, and I'm very bothered by the fact that Bard didn't really make clear what was going on. The district court sustains quite a few of your objections. They sustained the demonstrative exhibit, sustained the objection about the non-disclosure, and says Hurst can't testify in certain ways. It's a rebuttal. Anyway, so why isn't it your responsibility to squarely put these matters before the district court, and if it's incurable, then say the trial's bad?
So with respect to that point, so there's three objections that are stated on the record at the time it happens. The first is that a demonstrative comes in or is introduced that was supposed to be pre-cleared.
And he says you didn't, and he kind of scolds the plaintiff's lawyer. He says, the plaintiff's lawyer says, oh, I thought I gave it to you last night. The judge says, sorry, you can't use it. He sustained your objection.
So to be clear, the district court judge as to the first objection says, well, I understand it wasn't pre-cleared, but what's your substantive objection? And the substantive objection that's laid is it's inconsistent with his report, which is the disclosure objection, the same ones that move forward.
But why is there never a follow-up sentence? And Rule 26 says that in this situation, the expert can't testify at all. I mean, lots of conversation I feel is missing.
So to be clear, earlier in the case, a prior expert, Dr. Meeking, similarly testified outside of the report, and there was a discussion earlier about that, and there was a curative instruction that was offered as to that. But I think it's clear from the record that there is clearly objections on disclosure grounds. The objections clearly talk about how this isn't disclosed, it's not proper. And in terms of whether
but there's no, I mean, you keep using the word clearly, which I have a little bit of trouble with, but the particular objection was to the use of the first one. There are three objections. The first one is to the use of the demonstrative. The second one is kind of a long sidebar, and it's where you're saying that Hurst is flip-flopping. He's saying that this device migrated downward a very small amount, 3 millimeters, and now he wants to say it went up a much bigger amount, nearly an inch, 2.5 centimeters. So that's not disclosed, and I looked very carefully at document number 311, which is Bard's brief seeking the exclusion of the undisclosed opinions, and this is all in terms of Dr. Hurst as a rebuttal witness. I don't see any request for an instruction to tell the jury to disregard everything Dr. Hurst said. I don't see a motion for a mistrial. I don't see anything.
So I agree with you in terms of your discussion of how the brief is framed as Dr. Hurst as a rebuttal witness, but it does discuss the automatic exclusionary sanctions, which is obviously what is at issue, again, in the broader context of the trial. And if you look at when Dr. Stein testifies, our expert...
No, but aren't... How much of a mind reader is the district court supposed to be? You know, you're raising an objection about a particular point, and it seems you may have had a very good objection about the scope of, you know, the amendment of the report, the failure to amend the report. But you didn't really say that. You want the judge to kind of divine it from your motion.
Well, the objections that are lodged in those three contemporary ones are very I won't say clearly because I know you're having trouble with that characterization. They say this is not disclosed. This is inconsistent with this report. And at that point, I'm not sure what else we need to say from a perspective of.
Well, how about, and so we would like it all excluded, you know, and if you can't give it, you would have had to make a strategic decision at that point. Do you just say we need a mistrial? There's no way to erase this from the jury's mind? Because I actually have some other substantive questions about this, but we can stay on the procedural points for a minute.
Yeah, so I think at that point in time, because the exclusion is automatic under 26 and 37, it's preserved. That's all that was required of Bard.
So you didn't have to say to the judge, you have to exclude this.
I think it's clear from the context of how the objections are laid, where we say he can't testify to this. This is improper because it's inconsistent.
He blocks him as a rebuttal. He blocks the use of the demonstrative, and he says you can't say if it went up or down. All you can talk about, you know, is what's in your report.
Well, to be clear, that's after the jury already heard all of the statements about it going up. The opposing counsel then uses in closing to say, and this is why there's no problem. And again, I would contrast what happened.
But you're not disagreeing that the judge says you can't say whether it went up or down. Counsel has to change his whole examination.
So he did say it. He had already said it at that point in time, and the objection lodged. And again, I would just, to the extent you're having a problem with this from a preservation perspective, I would compare and contrast what happens when we laid that objection, when the exact same thing happens with our witness, Dr. Stein, on the final day of trial, where the other side says, objection, this is in his report, and the judge immediately says, sustained, jury disregard that statement. The context is no different. We said the exact same things. In fact, we said them more vigorously, and we said them 3 separate times. And the difference is, the judge says, and this is quoting from the transcript, we are where we are. I'm not sure what else we're supposed to do at that point.
Well, sure. I mean, I'm telling you what you're supposed to do. Can I ask you one other thing? At one point, Dr. Hurst says, none of this matters anyway. And if you look at the problem that Ms. Johnson had with this device, it had nothing to do with it being too high, so blood clots were accumulating, her legs didn't swell up, you know, all these things that are in the record. What happens is the thing breaks apart, and a chunk of it winds up in the right atrium of her heart. So I don't know why this up or down business is material at all.
So the reason that the up or down business is material is the theory of the case that was advanced by the other side is that the device has a propensity to migrate caudally, which leads to fracture, which leads to these other complications, including the ones that Ms. Johnson, the plaintiff, had suffered. And the testimony from Hurst and the testimony from our expert Stein is both the same, that when you place the device too high, when you place it at the level of the renal veins, it can't securely attach, because what the device is supposed to do is, the description from the Booker case provides a very helpful one. It's like an umbrella. You put it into the vein, it deploys and it broadens itself out and attaches to the walls of the vena cava. When it's where it's installed in the vena cava at the level of the renal veins, it can't attach because there's ancillary veins that come in at that point, and so there's not secure attachment, which leads to the same complications. And I think our point was, and what we made was, that's Dr. Hurst's testimony, and he acknowledges that can be a complication or a problem of that placement. Our expert says that, and even Dr. Goncharova, when she testifies, makes that same thing. Since we've spent so much time on this particular issue, I'll just move very briefly to the other ones, recognizing that I'm running short on time.
Go ahead.
In terms of our second point of reversal, we contend that it was error for the district court to sua sponte reopen the case to allow Dr. Goncharova to testify, and that under this court's precedents in Myers and in the AutoZone case, a treating physician cannot offer testimony beyond that the opinions cannot offer opinion testimony beyond that the opinions formed during the course of care and treatment. And our position is what happened in this case is that Dr. Goncharova's testimonies about warnings, about other things that she was not aware of at the time, are the type of opinion testimony that goes beyond the care and treatment And then finally, on our final
Did you
point,
preserve that claim of error?
I'm sorry, I missed your
Was
question.
that preserved?
So there was before Dr. Goncharova testified, there was a brief that was submitted saying that she should be limited in that fashion. There were objections lodged. The first objection was on the grounds that when the first hypothetical question is posed to her, the objection that is lodged is that it was beyond her care and treatment. The district court did not understand what that meant, so there's a sidebar. After that, the attorney at trial changes the phrasing and starts objecting on the grounds of lack of foundation. The other side has said that is not a preservation because the lack of foundation objections are not the same as outside the care and treatment. But we believe when you read the record in context, when it started with the district court not understanding the objection and then he changes the phraseology, the objection is nonetheless the same and the substance of it was preserved.
So how do you draw the line? This strikes me as one of those things for the district court's discretion. She is allowed, I would imagine, to explain what factors made her choose the Meridian device. You know, that was vis-a-vis a particular patient, Ms. Johnson. And though that decision to use the Meridian device is informed by the warnings that she was aware of. And of course, this whole case is a strict liability failure to warn at this point. Lots of other theories have fallen away. So she necessarily has to be talking about the warnings that she read and saying, gee, if I'd known, she says, if I'd understood its unreasonable risk, she wouldn't have used it. No, I wasn't aware of that. Would that information have been important to you? Absolutely. You know, so she's talking about her treatment of this patient.
So
I mean, you know, there's a general specific line, and why isn't that for the district judge to draw?
Sure. So I would say this court's precedent draws a line that the Myers case and the AutoZone case say opinions formed during the course of care and treatment don't need to provide the disclosure. And again, I would take a step back and say we're in this position only because Dr. Grunter wasn't deposed beforehand. There wasn't a report provided.
But you could have deposed her if she was on the witness list, right?
We could have deposed her.
She was on the witness list, right?
I believe she was, and there was a trial subpoena issued, which is obviously what led to the things happening at the 11th hour. But to be clear, at summary judgment, and the way we thought this trial was going, the bar thought this case was going to be tried was on the basis of Dr. Hurst's testimony. So at summary judgment, the plaintiff's attorneys took the position that they didn't need her testimony, that it was unnecessary, that they could prove causation, they could prove the failure to warn theory solely through expert testimony. So I think when Bard went into this trial, the anticipation was that was their theory, that was how they're going to present it. They were going to only use experts and not the witness. So I recognize we could have, but I think given the way that the case unfolded and positions it was taken at summary judgment, that's not how it played out, I guess, in practice.
Okay.
And just because I only have a couple minutes left, just turning very briefly to the presumption of non-defectiveness under Wisconsin law. The district judge at summary judgment rejected that. The instruction was requested, and it's our position that both as a matter was.
I don't understand why this matters, since your client prevailed before the jury on the design defect issue. So who cares what the instructions were or weren't?
So on design defect strict liability, yes, but under Wisconsin law, the instruction applies to both warning strict liability design defect and warning strict liability and warning strict liability design defect. So because we lost on the strict liability claim and the instructions applicable to the strict liability claim, even though it is a warning defect claim, we believe it's important that they would have gotten the instruction. And with that, because I only have 1 minute left to roll, and I really do want to save time, if it's all right, I would like to reserve the rest of my time.
Certainly, counsel. Mr. Siegel.
Thank you, Your Honor. May it please the court. I want to simply hearken to the waiver considerations expressed by Your Honor. needless to say.
But let me say, as you do that, you were playing a very dangerous game. I mean, it's shocking to me that the difference between 3 millimeters down migration, sort of against the flow of the blood, kind of a weird thing, versus 2.5 centimeters up was not disclosed. What's an expert report for?
Your Honor, we did not dispute that was a change in opinion.
And so you violated the rules.
We violated the rules, and
you're extraordinarily lucky that the defense did not move for sanctions, including precluding the whole theory of liability.
they didn't do that, Your Honor.
We know they didn't do that.
I don't dispute that.
What comes across in this case is that the plaintiffs deliberately flouted their disclosure obligations in the hope that they would catch the defense sleeping, and they did. But that doesn't put your side in very good light.
Your Honor, I don't believe that the lawyers at trial were deliberately sandbagging the defendant.
Why didn't they disclose Dr. Hurst's opinion?
They acknowledged that they should have. They did. They acknowledged that, Your Honor. And there's no dispute that there was a violation of the rule. We're not here defending on that basis. We are, however, defending on the basis that Your Honor raised at the outset of counsel's argument, which is there were many, many things that the defendants could have done. Short of a mistrial, Your Honor suggested that there was nothing preventing them from immediately moving for a mistrial. But another thing short of that is they could have said, well, we'd like some time to digest this and figure out how to cross-examine Dr. Hurst on it. We cited a case from this court.
Do they do that in that trial brief, docket 311?
That, as Judge Wood noticed, that was entirely geared toward not allowing Dr. Hurst to come back as a rebuttal witness, which he did not.
Right, on page 8 it says, allowing Dr. Hurst to testify to an entirely new opinion in the rebuttal portion of plaintiff's case would also cause a significant disruption to the trial. That's Bard's language. And at the end of that paragraph, it again repeats, in the rebuttal portion of Bard's case. And then it winds up saying Dr. Hurst's testimony, as I read it, meaning in the rebuttal portion regarding his new undisclosed expert opinion must be excluded. And there is no rebuttal, right?
There was no rebuttal.
So it never comes in the rebuttal.
That's right. I think the fact of the matter is that as the court has sensed by its questions, this issue of where the filter was placed and whether it migrated up or down is not a significant issue. And to whatever extent, and we're sort of beyond waiver now and talking about harmlessness, but that is worth diverting to for a second because the jury might well have concluded that it migrated one way or another. We don't know. Or the jury might have accepted Dr. Stein's testimony that it didn't migrate at all. And again, as the court noted, the jury found for the defendant on the issue of design, and that on both theories of design. And that has to do with, is there some inherent design flaw that makes the filter likely to migrate up or down? It doesn't really matter. What the jury found for us on one theory, which was strict liability failure to warn, and that theory had to do with, had there been more warnings about the propensity of this thing to fracture, the treating doctor would not have used it, would have used a different filter. Back to waiver.
There's all right, in the discussion with Dr. Goncharova, there's a point where it must be you saying, I'd like you to assume that as of 2007, Bard was aware that the G2 filter platform over a 6-month period of time demonstrated total migration of 62%. Was that information you were aware of? And she responds, I did not know that information. And then, would it have been important? She says, yes. Unacceptable risk of migration. So that seems like migration is a topic that's being pursued.
But I don't Migration, yes, but the direction of migration. The idea that the filter can move or break and move, and thereby, perhaps get into an organ or someplace it shouldn't be, that was the subject of some discussion. But the change in Dr. Hurst's testimony that they focus on is, originally he said in his report and his deposition that it migrated, again, we're talking about very, very small distances
3
here,
millimeters.
down, and at trial he said, well, now it's migrated up, and
But how is that a typo?
Your Honor, I think what happened at trial is that the trial lawyers looked at the report and said, maybe this is a typo, or maybe he
It's not a
misspoke.
typo. 3 millimeters is so different from 2 centimeters that the direction of movement, whether or not that's a typo, 3 millimeters and 2 centimeters are orders of magnitude different.
That is true, Your Honor. That is true. But I suggest that it's not our job as appellees to explain why they didn't pursue this. And my guess is that, in fact, it was not a big issue in anyone's mind.
Well, what
didn't-
they say is, and this is certainly something that I've heard people say before, was that their concern was if they adopted the cross-examination route, that the jury would just be hearing over and over again about Dr. Hurst's undisclosed opinion, and it might reinforce it in the jury's ears instead of undermine it. Now, you could say Dr. Hurst is incompetent, he doesn't know the difference between up and down, and, that's
Millimeters and centimeters.
millimeters and centimeters. We all had like these little rulers when we were kids that had things marked off.
Well, Your Honor,
But you didn't. So they may have had some reason for not wanting the red. Of course, we'll never know. If they had asked, if the district court had said, "Here's what I'm going to do. I'm going to allow you to cross-examine. I'm going to give a cautionary instruction. I'm going to give another cautionary instruction." Then I would have expected the debate about whether that's enough to cure the prejudice or whether the only thing to do is to throw away the trial.
Yeah, they didn't do any of that. I mean, we cited a case in our brief from this court called GICLA, G-I-C-L-A, 572 F. 3rd 407, which is a very similar situation in which there was a change in an expert's opinion. And this court said that focused on the fact that the adverse party could have asked for a break to figure out how to cross-examine the witness. It did not do that. And the court says, we have recognized the propriety of such measures, i.e. cross-examination, to correct Rule 26 violations. They could have done that.
The essence of your argument is that even though Rule 26 is designed to be self-executing, if you don't have an updated report, the testimony is supposed to be excluded. But what you need to say is, on top of that is still the broader principle of harmless error, that in fact, with all of these other potential remedies out there, we just have no way of knowing the impact of this.
The broader principle of harmless error and the broader principle of preservation of error. I mean, Rule 26 violations are not exempt from the preservation rules. And they just didn't do that. And we have not talked about the fact that the very first time he said this supposedly mind-blowing, case-changing opinion, they didn't object at all. They just didn't. And then the 3 times they did object, those objections were sustained. So there's just I'm in the position of agreeing that we made a mistake, but it was a mistake easily remediable by them or preservable, and that is and they did not do that. And we insist on the preservation rules and we insist on the harmless error rules.
I would like you to say a few words about the Wisconsin statute and the impact of 510K clearance.
Yeah, that I think the district judge was entirely correct in rejecting that proposed instruction. as we point out, that it so happens that the MDL judge in this case, before this case was remanded back to the trial court in the MDL judge actually had another case involving a Wisconsin plaintiff and applied Wisconsin law, and the defendant moved for summary judgments on the basis of this presumption, saying, here's what the presumption says, and the plaintiffs have no evidence to overcome it. And the MDL judge in Arizona looked at that, as have other courts in other medical device cases, and said these kinds of instructions, and specifically in that case, the Wisconsin instruction or the presumption that is the basis of the instruction.
Why is what a district judge in Arizona thought pertinent to this appeal? I understood that you were asked a substantive question. We have to decide. We will decide as a legal matter.
I
was getting to the substantive ruling, Your Honor.
What I want to know is, on the substance, is it a problem in your view, is your theory that there's a problem with this record, or is your theory that everything that goes through, the Class 2 510K process ineligible for the Wisconsin presumption?
Both, Your Honor. I mean, the 510K process is focused on equivalence, not safety. I
thought it was in the alternative, to be honest. I thought you could either show to be substantially equivalent, the device must have the same intended use as the predicate device, and either have the same technological characteristics or be as safe and effective. That's what this court said in the Kaiser opinion, looking at these 510K cases. Now, it happened to be Indiana, but it was a very similar.
It did. This court did hold that in Kaiser and held that the claim was not preempted in Kaiser. Now, I realize that that was a substantive preemption holding, not a holding about an instruction. But the Wisconsin statute gives this presumption if there are relevant standards, if the product complied with relevant standards. What would be the relevant standard in this case? That's what's missing.
That's why I'm asking you if it's a record-specific problem. If they just didn't put relevant standards, or they don't happen to be there for this device, that's one thing. And nobody's saying everything about the entire universe of Class 2 devices. That's
right, Your Honor. That our narrower argument is, I guess we're not arguing that 510K clearance for a Class 2 device can never yield this kind of presumption or instruction. But in this record, it was incumbent upon them to show the district court some relevant standard that would bring it within the terms of the Wisconsin statutory presumption. What is it? We said in our brief, they never say what it is. You might ask counsel that on rebuttal. What is the so-called special control, the three special controls that are never actually quoted or identified, but sort of alluded to in a footnote in appellant's brief? I think what they're referring to is controls about sterilization hazards, something called a biocompatibility control. It has nothing to do with any of the issues in this case. The issue in this case, or the issue on the theory that we prevailed on, was there a failure to warn of a hazard? Well, what was the hazard? We were asserting that the hazard was the propensity of the filter to fracture and thereby cause injury. There is no special control that's ever been identified that has anything to do with that theory or anything close to that theory. And I just don't think it's ever been identified in any of the briefs. And I think that's why all of these other cases, admittedly, they're all district court cases, and of course not binding on this court, but that's why all of these cases involving these presumptions or these requested instructions come out the same way. If the court has any further questions, I'll be happy to answer them. I'm almost out of my time.
Mm-hmm. Thank you.
Thank you, Your Honor.
Mr. Curtis, anything further?
So just a couple of quick points. So first, on the presumption of the defectiveness, the way the district judge decided this was the categorical rule that 510K is not safety, and therefore it would never apply. We have identified the specific standards, and what I would direct the court to is the briefing and the regulation that's discussed in Booker. It's 21 CFR 870.3375 that delineates the 3 special controls for intravascular filters. And to your point, Judge Wood, Kaiser talks about the role that special controls play for class 2 devices. And here we have, by FDA regulation and on the FDA's website, the specific special controls that are applicable to the testing, labeling, et
But
cetera.
they're very vague. You know, I looked at these guidance documents, and they really, you know, just speak at an extraordinarily high level of generality. Like you're supposed to, in your clinical investigation, consider the following items: study design, study hypothesis, samples. I mean, this is just glittering generalities, it seems.
So there are the intravascular filter guidance document is written, I think, from a reasonable level of generality, but it has
Pretty
specifics.
high level of generality.
In fairness, through the administrative process, and we delineated all the rules. The FDA said these are the special controls we conclude in our expert judgment are sufficient to provide reasonable assurances of safety and effectiveness. So I do think that there's some level of administrative deference that's owed here to what it determines. And then moreover, what I would point to, and this was in the record, is Mr. Van Fleet, when he testified, specifically walks through how the process works, the role that the intravascular filter guidance documents does, the process of determining tests, what the FDA requires from a labeling perspective, et cetera. And all we're asking for in relation to the presumption was a statement that the jury is entitled to, determine the presumption, and the jury can say it's met or it's not met. But that's where the failure to instruct was this categorical ruling. It could never apply, and all we're saying is we were just entitled to a simple presumption. And then I know I'm out of time. Just very quickly on the preservation
Counsel,
point.
your time has expired.
Okay, thank you.
The case is taken under advisement.
Thank you.
We'll hear argument now in the case of Hartford Accident and Indemnity Company against Lynn. Mr. Stinson.
Good morning. The underlying issue, I think, here is the relationship that big, giant insurance companies have with people who that pay for buy their premiums, pay for insurance coverage in case they have a loss. And in particular, unlike a third-party situation and a first-party situation, in this case, my client's, Mr. Lynn's employer, they purchased underinsured coverage. This case all began when Miss Chicky, who was working as a stripper at Club O, got drunk, got on I-294 and crashed into the side of my client's truck as he's driving from the food deliveries for Win-Win Seafood, causing his vehicle to go off 294 into the ditch and seriously injure him. Miss Chicky was not only drunk, she had no driver's license and hadn't had one for 5 years. The last I checked, she's still in prison for this. And in this situation, Hartford, after we made an underinsured claim, has never taken any position about whether Miss Chicky was at fault for this. So the question becomes, is it okay when his employer...
Counsel, we are not a jury. If you would make a legal argument, we'd appreciate it.
There are 3 legal arguments that we made in our brief. The first one is that under the Hennessy case, which was decided by the Seventh Circuit Court of Appeals, that when we requested arbitration, or it was decided that the provision in the policy that allowed for arbitration but did not mandate it, that once that decision was made and we had a 155 claim, that under Hennessy, the bad faith should have been arbitrated. And we read the Hennessy case as saying and mandating that in that situation that should have occurred. Judge Kennelly did not address that.
Let me just narrow the point here. If we look at the arbitration clause in the endorsement, where from that language are we able to draw that the workers' compensation would be pulled from that language? On the motion to compel, the question was whether or not the district court erred in making the determination not to compel arbitration on Hartford's question regarding workers' compensation.
We didn't appeal that. I mean, the part about whether or not the set-off should have been decided by district court, we did request that the arbiters decide that, but once Judge Kennelly decided that, we never took issue with it, and our notice of appeal does not do that, suggest otherwise. There are cases out there where courts have mandated that set-offs be decided by arbiters, but there is plenty that support exactly what Judge Kennelly did on that point, and we didn't appeal that specifically because we thought that that was a reasonable position for him to take. The further point that...
Can I just break in and ask, so as I understood this, your complaint as far as it's concerning arbitration is that the bad faith claim didn't get added to the scope of the arbitration. But the issue there is, arbitration, as you know, is a creature of contract. This arbitration agreement isolates two things: legal entitlement to recover damages, that's number one, and amount of damages, number two. And the arbitrators took that on. There was no big question about legal entitlement. They figure out an amount of damages, but just because you agreed to arbitrate that doesn't mean everything is suddenly arbitrable. It depends on the contract.
Well, all I would say on that is you've correctly stated the facts, but Hennessy had the exact same facts, and Judge Posner said that reverse the district's court decision not to send the 155 claim to arbitration.
But the language of the arbitration agreement, if I'm recalling, was a bit different in that instance.
I disagree.
It really depends on the scope of the clause.
There was, in the Hennessy case, there was nothing that mandated that the 155 issue or any discussion about it.
Required arbitration of any dispute that involved interpretation of the agreement. That's a different clause.
Well, here's the question. The question was what was fair compensation, and the question was what were the damages. And the question also was whether or not there was a reasonable delay under 155 in paying that. All that's one issue. And the Judge Posner correctly said that if you're going to have...
Judge Posner writing all by himself?
No.
No, it's an opinion of the court.
Opinion of the
Opinions
court.
speak for the court.
That's correct.
You should refer to the opinions of the court.
Okay.
We're not making ad hominem arguments here.
Okay.
And honestly, the issue that I would like you to turn to, since time is never as long as you think, is the question whether the district court made a mistake by refusing to offset basically by refusing to treat the entire $100,000 that Mr. Lynn received on the ground that this was the workers' comp lien and he had to pay it, sort of following, in a sense, the Berry case, or whether the district court was correct instead to follow the Roberts line of cases and say, well, Illinois has chosen, this is of course a question of state law, and say that Illinois has chosen to decide that you didn't, quote, actually receive the funds that you had to devote to the workers' comp lien. So there are two distinct lines of cases, and how are we supposed to choose?
Well, this is clearly a Roberts situation because they wanted to argue, which Judge Kennelly rejected, that the set-off reduced the amount of the policy limits. And that was clearly rejected. And Roberts says that once you start getting awards that are in excess of the policy limits, that at that point, the goal is to fully compensate the injured party, and Roberts applies. And in Roberts, they had the same situation where there was an inadequate recovery no matter what because the award is bigger than the policy limits. That wasn't true in Berry. I think Berry is a very different set of facts because it really gets into this argument, whether you accept it, that the question in Berry was this argument about whether or not you could reduce the policy limits. And that's not what happened in this case. And Judge Kennelly correctly said that set-offs are not coverage issues. And their argument.
Why is it different, though, than just giving Mr. Lynn $100,000 and saying, this is your award. Now, whatever other agreements you have or other subrogation obligations or other debts, is your business. It's not ours. And so why doesn't the whole $100,000
I'm
come off?
a little confused. The arbitration award was $1,050,000.
I know, it was $1,060,000,
Ms. Chicky's
$70,000.
policy was $100,000. We didn't dispute that they were entitled to a set-off for that. What became the dispute is that whether or not they should get a set-off under Greeley for the workman's
For
comp
the workers'
award.
comp, yeah.
So, I mean, that was essentially what was.
But it was about $75,000, right?
I'm sorry.
The Hartford Fire lien was $73,000 or so, right?
Well, that was the lien on the recovery, and we cut them a check back from Lynn's recovery from Ms. Chicky. So we gave them a check before this ever got issued.
And the question is that a recovery that Mr. Lynn actually got, or is that money that he never saw?
Never
thus
saw.
Under Roberts.
Never saw a penny of it. I got the check from Chicky's carrier and immediately cut a check out of client funds to the Hartford. So the other part of
Is
this
that not a tangible benefit, though, as explained in the Berry case, footnote 5?
I'm not sure I understand the question. I mean, the point of the matter is that that's money that he gives up that he never received. And if the idea here is to use insurance coverage to make him whole, the only way to do that is when he's given up that money and now he's got an award at arbitration that's in excess of the limits, that the only way to compensate him for that is to allow that money to be recoverable. I want to turn quickly to the dismissal of the 12B6 dismissal of the bad faith claim. And specifically, the district court found first that it was not futile and allowed us to file it. Then they said, well, Judge Kennelly said, well, it's a little long under Rule 8, shorten it down. 130 days later, he then did a reversal and dismissed it after and found that it was futile. So our position was that his original judgment on this, saying that it wasn't futile, should stand and that nothing factually had changed in the interim on that. And it's important to keep in mind here, when he does his reversal, he tends to focus on this question of whether there was delay caused in the district court. But that's not where we're alleging the delay and the problems occurred. We're alleging that the delay and the problems occurred before the arbiters, where we issue in September of 2019 interrogatories and production requests, and 2 years later, they still haven't answered them yet. And the policy itself says the local rules apply, and they won't tell us what the local rules are, even though they've issued interrogatories and production that we promptly answered under the Illinois Supreme Court rules. And they complain, well, you didn't produce your client, but of course, how can I produce my client when they won't even give us written answers to written discovery? So I think it misconstrues the fact that we're not saying that that the delay was caused in the district court, although I have never seen a case anywhere in the nation where a district court has ordered set-offs to be decided before you have an arbitration award. What if this arbitration award came back at $50,000 and then we already admit there's a $100,000 set-off for Ms. Chicky's policy, so now we've just done all this work and all this decision-making to no avail. As it turned out, there was a need to do it, but we didn't know that when he made the decision to say, I'm going to resolve this issue without discovery and without an underlying arbitration award.
Did you ever ask Hartford to make a partial payment on this?
Oh, yeah, hundreds of times, yes.
So you did ask them, you know, if you calculate everything their way, you come up with about $579,000.
Right. So the Illinois Administrative Code 59 19.05 says that the insurance company's obligation in the beginning is to complete an investigation and pay any undisputed amount within 30 days. I can't tell you how many letters I sent to that effect. In other words, if you're not going to honor our demand for $900,000, the remainder of the policy, at least pay us the undisputed amount, which is required under statute. And the House case supports that conclusion as well. I got about 2.5 minutes left. I'm going to save it for rebuttal if it's okay.
Certainly, counsel. Ms. Murphy-Petros.
Good morning, Your Honors, and may it please the Court. Melissa Murphy-Petros for Hartford Accident and Indemnity. I'll go first to the $73,000 issue that Judge Wood raised. Our position, as you've read, is that that full $100,000 that was received by Mr. Lynn needs to be reduced from the policy limit pursuant to Section D2 of the endorsement, which states all sums paid or payable on behalf of the insured. That's the way that the language reads. There's nothing ambiguous about that.
So here's my only issue with that. There are these two lines of cases. There's the Roberts line and there's the Berry line. And if you were to ask me, the Berry line makes more sense. But on the other hand, this is a question of Illinois law, and Illinois seems to care about what they're calling actual receipt of the money. And in Roberts, it looks a lot like this case. And if you were to follow Roberts, I think you would say Mr. Lynn did not actually receive that $73,000. And then you might say, well, you know, two lines of cases. But Illinois courts have actually reaffirmed Roberts even after this court decided Berry. There's acuity against Decker, maybe other cases. And so even if I personally think it's a foolish rule, no one in Illinois asked me to make up the rules for Illinois. So isn't it our obligation to follow what we think an Illinois court would do, and doesn't that take us to Roberts?
Yes, and that also takes me to my second point with respect to Berry. The second provision, an alternative provision in the endorsement, is Section D4, which prohibits the receipt of duplicate benefits. And the Berry court predicted that in Illinois they would look at this same situation and say that the full amount received from the settlement with the underinsured driver was in fact received for the benefit of the injured party, and that the amount paid to satisfy the workers' compensation lien was extended on the benefit of that party. I mean, otherwise, you know, here, for example, Mr. Lynn would have had to pay that lien himself. It's a statutory obligation. So the fact, as Berry says, the fact that the middleman was cut out doesn't alter the fact that he received it for purposes of D4.
Sure,
So,
and I understand that line of argument. I'm just having trouble seeing how it's consistent with Roberts, especially since this is also a case where now we know from the arbitrators we'll accept that $1 million and whatever it was, $1 million and change award. He's not going to get compensated more than the total amount of his damages. He's still under, you know, based on all these various insurance policies. He concedes that the first $100,000 goes off the policy limit, so he gets down to the $900 readily. And then the question is, how many other deductions are there? But I know it's a little bit hard to put yourself in the mindset of somebody who's taken an approach that doesn't seem logical to you, but why isn't this the way Illinois has chosen to allocate these losses?
well, again, I think we just need to focus on the fact that we do have two separate policy provisions, either one of which could apply here. The Roberts and its line of cases focus on D2 in terms of, you know, what did this person actually receive in calculating the reduction of limit, whereas Berry looked at Section D4, which specifically says no receipt of duplicate payments, and that this would be a duplicate receipt of workers' compensation benefits to not apply this additional further reduction to the policy limit. So I think also I would say, and I know I know you guys are who you are, and so I should maybe go down the street and say this. I do think the Roberts, it's a stretch. It's one little paragraph in the appellate court decision in Roberts, and that decision then was later reversed by the Illinois Supreme Court. There's really no analysis in Roberts, but to your point, yes, other Illinois appellate courts have picked up on that paragraph. But with respect to D2, here D4, we maintain in our briefs and below also applies, and that was the provision that the Berry Court was looking at. So we would advocate the same result with respect to the $73,000.
Okay, thank you.
With with respect to, I will just turn briefly to some of the questions that were raised with opposing counsel. With respect to the arbitration of bad faith and workers' compensation, the endorsement does not provide that. As Your Honors recognize, the endorsement states that arbitration may be had on the liability of the underinsured driver, the amount of damages incurred. These other issues certainly are not within the scope of that provision. Hennessy doesn't change that result. It's a very different arbitration agreement. It says what it says, but it's not the same as here. Certainly, we maintain that the district court correctly dismissed the bad faith claim. Again, for all of the reasons in our brief, they're really, as Judge Kennelly, we maintain properly found, we didn't have an obligation to pay the claim until the arbitration, which was requested by the defendants to ascertain the amount of damages, was held. When that arbitration was held, we paid the claim within 2 months.
So is it your position that because Mr. Lynn was the requesting party for the arbitration, that he has somehow waived any complaint about the amount of time the arbitration takes?
No, that's not our position. However, as discussed at length in our brief, to the extent that there was a delay in the arbitration, that really falls on Mr. Lynn's side of the V, so to speak. He requested arbitration in June of 2017, and his claim in the arbitration was held in abeyance at his request of Hartford while they worked through the case against Ms. Chicky and the workers' compensation proceedings. On July 11th, 2019, which is the date on which his workers' comp claim was resolved, he issues what he calls a final policy limit demand to Hartford of $900,000 on threat of a bad faith action. In that letter, he also says he values his claim at $2.5 million. November 21st of 2019, Hartford answers, explaining its position with respect to the workers' compensation reduction of the limit of insurance.
But is that the letter where Hartford has this extremely lowball, $100,000?
They offered $100,000, yes.
I think that's pretty, I mean, even as they've just conceded that the policy limits might be considerably higher.
I obviously wasn't involved at that stage, but in any event, at this point now, there is a dispute on claim valuation. He says
but what's happening
2.5.
between July 11th and November 21st? Because he's saying, I am repeatedly asking.
There was, yes, there were a few letters from Mr. Lynn. I don't know, I can't tell you precisely, the record isn't clear on the Hartford side, although as we argued below, and Judge Kennelly also recognized, I think, it takes time. They're doing their research and their coverage analysis and what have you. So, 4 months to respond is perhaps a little less than ideal, but it's not unreasonable, it's not vexatious. So now we're at November 21st of 2019, we have a dispute on the actual damages, $2.5 or $100,000, let's go to arbitration. And at that point, the arbitration took quite a long time. And as detailed in our brief, these were many actions that were brought by the defendants, various motions to compel arbitration, motions to subpoena numerous other folks not involved in this litigation. There was a motion to compel claim adjustment, a motion to withdraw the arbitration demand, reporting us to the Illinois Insurance Department. I mean, there's all kinds of things and that we did not undertake. So once the arbitration finally occurred, he was paid within a couple of months. So think Judge Kennelly saw all that and properly granted the 12b6 motion to dismiss that claim. Unless your honors have further questions for me? Nope. Thank you.
Hearing none, thank you. Mr. Stinson, anything further?
Yes, thank you. Just a few quick points. One is the Buis case, which Judge Kennelly relied upon when he initially said that our counterclaim for bad faith was good, is a right-on point case that basically says...
There was no bona fide dispute between the parties in that case, right?
Right, and there wasn't in this case either. They've never valued this claim. They've just insisted to go to arbitration. They never came back to us. They did make a settlement offer, but a settlement offer is not a valuation of the claim. If they would have come to us and said, you know what, we've done our investigation...
This is not a jury trial, counsel.
If they would have come to us and said, we did an investigation, and based on this fact, this fact, this fact, and this fact, this is how we value the claim, that's one thing. But a settlement offer is just basically, we're denying liability, we didn't do anything wrong, here's our take it or leave it number. That's not what insurance companies are allowed to do. The business of insurance is when somebody that paid a premium to your company makes a claim, you within 60 or 90 days, according to Elliott Flood, the insurance expert...
I sincerely suggest that you calm down.
Elliott Flood's report, which was considered by Judge Kennelly, says that insurance adjusters have an obligation within 60, 90 days of somebody making a claim to complete an investigation and come up with their valuation that is fact supported and to take a position about liability. They never did that. To this day, they've never done that. And we got their internal records at some point, and we found out that their arbiter, who valued this case at $1,050,000, he signed the verdict form that said that that's what the case is worth, that internally they had valued this claim at $200,000, which is a vast world of difference between those two numbers. Their own hired person that showed up at the arbitration agreed it was worth over $1 million. I would note that the district court, under Greeley, accepted the reasoning of the Greeley court, but then had a misapprehension of the facts. This court can correct that. It can look at the facts and realize that Greeley, the language in the Greeley policy in this case were the exact same endorsement, even though they're different insurance companies, and that Greeley is on all fours, and that when you take the facts and you apply Greeley, as the district court did, if he had been correct about the facts, he would have reached the correct conclusion under Greeley.
Thank you, counsel. The case is taken under advisement. Our third case for argument today is United States against Holden. Mr. Holler.
Good morning, Your Honors, and may it please the Court, David Holler on behalf of the United States. Title 18 United States Code, Section 922A6, prohibits making a false statement intended to deceive a licensed firearms dealer with respect to a fact material to the lawfulness of the sale of a firearm, quote, under the provisions of this chapter. Under Title 18, Chapter 44, a firearms dealer may not sell a firearm to a person who is under felony indictment or information. And Holden has admitted that he falsely, and with intent to deceive that firearms dealer, stated that he was not. Under binding Supreme Court precedent, that really is the end of this case. It is irrelevant whether the underlying statute is unconstitutional, and therefore the district court never should have reached out to decide that question. Alternatively, as the government has also argued here in another context, 18 U.S.C. Section 922N is constitutional, and therefore that would also provide grounds for reversal of the district court's decision here. This really is a statutory construction case. What does 18 U.S.C. 922A6 require? And essentially, I think both the district court and my opponent stop halfway through the statute. They don't read to the end of the statute. And all of the other decisions that we've relied on, Dennis, Knox, Bryson, all of those cases state you don't reach the constitutional question. You simply look at the statute.
So, Mr. Holler, what's the point of the statute if the thing that's being lied about is actually an immaterial thing? You know, you lied about the fact that you were born on a Tuesday as opposed to a Wednesday, but nobody really cares whether it was a Tuesday or Wednesday.
Well, there's, I mean, if the statute doesn't ask for that information, if Title 18, Chapter 44 doesn't request that specific information, then it would not be material. But both 922D1 and 922N, which are part of the chapter, essentially require the firearms dealer to know whether or not the person is under indictment or under information.
Right, and so what I'm trying to get at is, what I think your opponents are arguing is that once we apply all this, you know, Bruin and Heller and everybody else filter to the underlying question, under indictment or under information, is the piece of information that Mr. Holden lied about something that's material at all? Are there reasons that the government would have to collect this piece of information, or does that not matter? Is it just a rule that you can't lie on a government form even if you don't see the point of the question that the government's asking?
It's the latter. All of the cases that we've cited, I think, I mean, look, I suppose Knox might be the best case. I mean, in that particular case, the Supreme Court had already, I believe, struck down on Fifth Amendment grounds the statute. They said we can't require people to report that they've been wagering, they've made money from gambling, from wagering, because of course then they're going to be indicted for that crime at the time that gambling was illegal. And they said, well, what do? You either refuse to file a form, you file a civil suit against the government, you tell the truth, and then when they try to charge you with that, you invoke your Fifth Amendment rights. But the one thing that you can't do, the one thing you're not allowed to do, is essentially say, I want to avoid this issue entirely by lying. Then you violated another statute. So Mr. Holden could have filed a civil suit. I mean, there's a case pending before this court.
There are many such suits floating around in the courts. Yes.
There are many such suits pending. He could have told the truth on the form, and if the firearms dealer denied the form, they could have sued. Firearms dealer might have been able to sue if they wanted to sell him a firearm anyway. But the one thing that he can't do, and this is just black letter law from these cases, and I recognize they're older cases, but they've never been contested in any serious way by the Supreme Court. This court has followed them in Lawton and Moore and the other cases that we've set forth. So this case is really just at an end on that ground alone. I am sure that this court will have plenty of opportunities to resolve the constitutionality of 922N and many other firearm statutes under Bruin, unless the Supreme Court clarifies or Bruin in some way before then, and then you can interpret it under Rahimi or under whatever the other new Supreme Court case is. But in this particular case, this particular indictment was a 922A6 indictment, not a 922
What was the material
indictment.
fact that was lied about in this case?
That the defendant was under felony information, which he was. And he admitted that at the change of plea hearing. And he
You're
knew
saying
that.
at that moment, I think there's an interesting ex ante, ex post dimension to this issue. At the moment that he misrepresents this fact, he lies about whether he's under felony indictment or information. Had he told the truth, the firearms dealer in that moment would have been required to deny the sale. Now, at some future point, you know, if 922N disappears from the U.S. Code, there might be a day when that isn't the case anymore. But really right now it is. And I guess what you're saying is that self-help about the constitutionality of the underlying question is not a rule of law kind of approach. You know, you have to tell the truth.
That's been clear since Cap and Kay in the 1930s. And I think the Bryson case...
So what do you think would happen if next year the Supreme Court holds 922N unconstitutional? What can happen in 2025 if somebody gets this question on the form? The form stays where it is.
So for person in that case? That's an open question, Your Honor.
We know it's an open question. That's why I asked you what, in the position of the United States, would happen.
I think the official position of the United States, although the Supreme Court in Bryson left that question explicitly open, is that in theory we could prosecute that case. I doubt that anyone would exercise prosecutorial discretion to do that. I expect that ATF would very quickly revise the form as it has in the past. But as a matter of law, could we do that? I think the answer is yes. But Bryson,
I was actually trying to see whether you would, at that point, rely on Section 922G1.
oh,
Or
well,
it's G2, I'm sorry.
I'm not exactly.
The one that says a felon can't possess a firearm.
Oh, well, for Mr. Holden,
The question would be, is being under indictment material to the question about felon in possession? Because under indictment one day, you may be convicted the next before the delivery of the weapon. It's a question about materiality.
that would, I suppose, be a question as well, Your Honor.
I know it's a question.
I don't know what the
That's why.
government will do.
All right.
I don't.
All
I
right.
don't know.
I respect the statement. The Justice Department hasn't taken a position on that yet.
We have a long ways to go before that, and I think we're trying to fight the battle of keeping these statutes constitutional for now. I would, although I don't think the court needs to reach the question, as I said, it is an alternative ground on which the court could affirm, and we do believe that Section 922N is constitutional. And I think cutting through all of the stages of analysis and everything else, I think what I just would like to say as my basic point is, in colonial times, we had the power to detain people for felonies and hold them in jail where they didn't have access to firearms for any capital offense. And capital offenses included counterfeiting and embezzlement and adultery and horse theft and all kinds of fairly minor offenses. And if we could do that, if we could take somebody's bundle of sticks and liberty rights and based on a probable cause finding, take them all away, on that same finding, we believe we can take away their right to purchase a new firearm.
So here's what is interesting to me about that argument. Not everybody, certainly today, not everybody even then was detained. There were some offenses that you didn't get detained for. Sometimes you could give a surety, right? You could do different things. And one of the arguments that I've understood is being made in many of these gun cases is that these across-the-board disabilities have got to go by the wayside. If Mr. Holden, had committed a triple murder, then maybe you could take his gun rights away if he's accused of something that drastic. If he's accused of swindling old people for, putting a new roof on their house or something, then maybe not. But more lines need to be drawn, it seems, under what the Supreme Court is telling us in Bruin, et cetera.
Your Honor, I guess my response to that question would be that if a specific defendant had a specific as-applied challenge to the statute, that's typically the way we do these. We don't strike the criminal statute and say, well, there might be some application where it's not going to make sense. We leave the criminal statute in place and we allow the defendant to sue. That's what's happening in the G1 context. In the G1 context, the defendants in the civil side are not saying this G1 has to be stricken because it doesn't allow for exceptions. They're saying, I, as applied to me, deserve a specific exception. Mr. Holden hasn't said, me, who was charged with assaulting a police officer, a felony, deserve a specific exception. He's saying, wipe away the whole statute. And he can't do that. And the whole statute cannot be wiped away because it is consistent with this nation's historical tradition of detaining people. I think if one goes back through and analyzes the cases that we have cited, I do think that they do support the notion that capital crimes, which were modern day felonies,
Broader, yeah.
there was very rare exceptions. I mean, Justice Marshall in the Aaron Burr cases seemed to say, well, before the grand jury indicts, probably you can be released, and then once the grand jury said there's probable cause, you're being held till trial. If that's the case, then we can certainly, consistent with this nation's historical tradition, bar someone. We're not, again, 922N doesn't even take their firearms away. Excuse me.
I'm sorry, what about the historical tradition of the presumption of innocence?
Well, there is a historical presumption of innocence, and Kayleigh has recently said, look, we can freeze your assets and prevent you from hiring counsel of your choice. Consistent with the presumption of innocence, if you're charged with a crime of, you can be, I think you can be told to have no contact orders with somebody. That implicates your First Amendment rights. The Second Amendment is to be put on the same plane as every other right. Every other right can essentially be taken away from you in prison. So we can take away some of those rights. And again, 922N does not even take away your firearms. It prevents you from buying a new firearm. It doesn't take away the ones you already have.
Can we
stand
back
into
up
my
a
rebuttal
moment?
time. I'm sorry.
I want to back up because this hasn't come up yet. It's the Huddleston case where the Supreme Court defines the conduct that's prohibited under 922A6, and that's making a false statement that a licensed dealer is using to determine whether or not you're eligible to buy a firearm. And so the hypothetical that Judge Wood posed, if you're born on a Wednesday but you lie on the form and say it's a Tuesday, would that lie be enough under 922A6?
I don't think that would be a lie unless there's a provision of the Gun Control Act that I'm unaware of that says that makes a difference. But one of you might know that. But I'm not aware of anything. But you would have to review the act to know the answer. The 922D1 and 922N say that this particular false statement was material. And that's what decides this case. I'm well into my rebuttal time.
Let me come back to a version of my question. Nothing is held invalid. But suppose the form calls for a Social Security number, right? And there's no federal law making it a crime for somebody who has a Social Security number to buy a gun. Form calls for a Social Security number. Under what circumstances would that be material if you lie about your number?
I mean, I suppose if it somehow interfered with our ability to determine your identity.
That's certainly one possibility. You claim somebody else's number. It disguises the fact that they would use the number to find if you had a conviction. So we live in a world where presumably there are things not at the first level material to some other statute where the information is useful in investigation. How do we figure out what that is?
Well, Abramski sort of discusses, and Huddleston both discuss the nature of the statute. Beyond that, I don't know that we've gotten into the weeds or the details of that to that level or degree. There is a separate provision, 924A1A, that for anything that is called for to be kept by the records of the firearms dealer. So that could encompass certain regulations that aren't called for specifically in the Act itself, in Title 18, Chapter 44. And I mean, Lawton sort of dealt with that already. So part of Mr. Holden's argument, ironically, seems to be we charged him under the wrong statute. But I think Abramski said that otherwise those statutes are essentially in par materia. I would like to reserve the last 30 seconds for me.
Certainly, counsel. Mr. Schmidt.
May it please the court. (922A6) is a very particular kind of statute prohibiting lies. And it's particular because it says that under 922A6, as Congress wrote the law, it's only actionable if the misrepresentation is material to the lawfulness of the sale. And to Judge Easterbrook's point, that's the limiting principle. That's what...
So what about my Social Security number question?
Your Honor, I believe that it would not be material.
Why not? Suppose the Social Security number is a means by which a search is conducted to see whether there is some disqualification.
To that extent, then I would agree with you.
Right. The Supreme Court has said that a fact is material if it has a potential bearing on something. Well, the fact that somebody's under indictment also can be used to search for other information.
But it's not just any kind of materiality. It's material to the lawfulness of the sale. And
But I think what Judge Easterbrook is saying is that the second layer, the false social security number or the false statement about one's status in the criminal justice system, can also be material to the sale. This isn't the only gun regulation. There are background checks that are conducted. The government sometimes, is trying to discover whether a person who is a perfectly lawful gun owner had their firearms stolen, which was then used to commit crimes, and they trace the stolen firearms with the kind of information they collect. So this isn't necessarily something that's picking on people who shouldn't be having guns. It's a body of information the government collects.
I agree. To the extent that a question asks about someone's identity, that's relevant because it could be material to the lawfulness of the sale, that person's identity. For example, presumably there are questions of status with respect to the firearm purchaser that remain constitutional after Bruin.
Well, take a simple example. Person honestly answers that he's under indictment. Before delivering the gun, somebody goes and looks at the indictment. And the indictment turns out to be for the crime of possessing a firearm as a previously convicted felon. Right? That wouldn't be relevant might not be material under N, it might be material under G1. And I don't see anything in the statute that says it has to be material under any given subsection.
That's
There
correct.
are lots of things you can track down with information.
That's correct, Your Honor.
Well, another thing the indictment might reveal is that you are not lawfully in this country,
Yep.
which relates to another subsection of the statute.
I respectfully disagree. I think it's 922N that drives the materiality of the question.
Well, it might. Take Judge Wood's example. Somebody who is not lawfully in the country can't possess a firearm. Suppose the indictment turns out to be for the crime of illegal reentry, having previously been removed as an alien. Right? That reveals the fact that the person is an alien. Or at least it reveals a substantial likelihood that the person is an alien. There are all sorts of things you can get out of an indictment.
I think that extends the term material to the lawfulness of the sale too far. And
Why?
Yeah, but because what we're talking about is the government's even granting that maybe there is no 922N anymore someday. I don't know. Maybe there will, maybe there won't. But the government has a strong interest in truthful responses to questions on the ATF form. And we've given you a couple of examples that might not mean that this is an automatic disqualifier in and of itself, but having gone to the indictment and looked at it, we've given you a couple of examples where it might turn out that there is a problem with this sale, and the sale wouldn't go forward if the firearm dealer realized, oh my gosh, this person is, not lawfully in the country, or this is a phony social security number, or any of a number of other things.
that's section 924A1A, Your Honor.
Fine.
And that's not what Mr. Holden was charged with. He's
charged with lying, is what he's charged with, and the predicate, the underneath, the next layer down is 922N. But you're defending the right to lie to the government.
No, Your Honor. The government's argument is premised on trying to project 922A6 as just a lying statute. It's not. It is the very specific statute that says a person can be held and criminally punished under 922A6 only if their misrepresentation is material to the lawfulness of the sale. And what is it that determines the lawfulness of the sale? It's the prohibitions of
It's
that
all
are
of the prohibitions in 922. It's not that you
correct.
get to
All of them
lie
in
about
all of them in
quite a few.
922G and also 922N in a different subject. But if it's unconstitutional, then it's not material to the lawfulness of the sale. That's
Is
what
it
that phrase means.
unconstitutional to prohibit sales of firearms to illegal aliens?
No.
All right.
At least not under this circuit's law.
No, Your Honor. But under Bruin and the heightened scrutiny that Bruin mandates, 922N...
I must say, if you want to rely on the language of the statute, let's look at the language of the statute. It says material to eligibility under the statute. It doesn't say material under the Constitution, right? It's asking a question about what else is in this statute. You don't seem to want to answer that, or rather, you really concede it's material to the lawfulness of the sale under 922N. And then you say that 922N is itself invalid. But I don't see how that, if we're talking about second-level materiality, how does that get back? It is material under 922N. Even if the Supreme Court holds 922N invalid, there will be no doubt that this answer was material under 922N.
Your Honor, I respectfully disagree. It's the prohibitions of 922G and 922N that drive the lawfulness of the sale. That's what that means. Otherwise, there'd be no point to having Section 924A1A, which says if you make any lie with respect to a firearms transaction, you're liable. That's what that's...
Congress, are you sitting here saying that Congress never enacts overlapping statutes? And we have 1001 too. The ATF is a government agency. It's a form. You know, there are 1001 prosecutions as well.
Your Honor, I concede that Congress many times enacts overlapping statutes, but they were very specific.
You're exactly right.
They were very specific on 922A6, and they made it...
But it's not the only place where there are materiality requirements. Judge Easterbrook alluded a few minutes ago to the False Claims Act. I mean, we understand what materiality often normally means. Pretty broad.
Right, but materiality under 1001 or materiality under Section 1623, that's a different kind of materiality. Those are general materiality statutes.
Why aren't they materiality vis-a-vis the transaction?
Because Congress wrote it differently. They didn't say that's material to the firearms transaction. They could have written it that way, but they didn't. They said material to the lawfulness of the sale. And if you
But you're excluding
the
excluding the possibility that well, first of all, you are inviting everybody to take the law into their own hands and kind of self-assess whether any question on any government form is or is not material to what the form is asking about. Doesn't strike me as a good strategy if you're filling out, you know, like the security clearance form or some of the other forms that the government has. You're also saying that there's no way after Bruin that a question about being under indictment or information could ever possibly be material to the lawfulness of a firearm sale, and that hasn't been decided yet by the Supreme Court. You're arguing for a privilege to ignore statutes that you think are eventually going to be held unconstitutional.
Not quite, Your Honor.
It sure sounds like that to me.
Mr. Holden is not attacking the government's right to ask a question. He's not challenged the constitutionality of that. He's not challenged Section 922A6 straight on. He's not raised any...
That's the problem, of course, since your client was convicted under 922A6 and not 922N. One would ordinarily think that the validity of a 922A6 conviction depends on 922A6 and not on the validity of some other statute.
It's a simple two-step process here, though.
It's not remotely so simple, as we've already been through in talking about what if the indictment is for being an alien who enters the United States illegally after previously being removed. It would reveal something that would make it unlawful for that person to possess a firearm, and therefore would be material, and so on.
The government took the appellee to task in its brief for saying that we reversed the right order of the question. that we should have started with A6 and then moved.
And the reason they said it is because that's the statute of conviction.
Yes.
Or in the statute in the indictment, let's just say.
But I would argue, Your Honors, that logically it makes sense to start with 922N, because if 922N is constitutional, then you don't get to the statutory construction question.
The Supreme Court has been very clear that you start with the statute and reach the Constitution only as a last resort. The proposal that we start with the Constitution and reach the statute as a last resort inverts the normal means that we've been told we must follow, and we do try to follow marching orders.
Understood. I would like to make the point that the government never raised the issue of 922D1 in the district court, and hence that argument is waived or forfeited. It only argued below that Mr. Holden didn't have a privilege to lie, and we concede that. He doesn't have a privilege to lie, but rather 922A6 says material to the lawfulness of the sale. That's driven by 922N in this case. And the government never argued.
Why in this case? Right? Why not say, we've been pursuing this, maybe this is just gilding the lily. Why not say the government can ask about an indictment because it might be material to any part of any of the subsections of this statute. And you can't know until you get an honest answer. All we know from the indictment, or all the indictment alleges, is that there was a lie.
But that's not the way Congress wrote 922A6, Your Honor. Congress wrote it very specifically, and in order to give meaning to the word lawfulness of the sale, you have to look to the actual prohibitions of Chapter 44 of Title 18. And those are contained.
Why?
Because
do you think an indictment would be invalid if it just alleged a violation of A6 and didn't name any other subsection?
I believe an indictment would be not particular enough if it didn't state what the particular
But
lie
why?
was.
Here, look, the problem is your client doesn't reveal what he's under indictment for, which might make it very hard, since your client lied in response to the question, might make it very hard to figure out what other subsection applies. All we know is, from the indictment, is that your client lied.
And just to be clear, you know, what you attached actually in your brief, this indictment puts all the bells and whistles from 922 A6 in here. Knowingly made a false and fictitious statement to Worldwide Jewelry and Pawn that was intended and likely to deceive Worldwide Jewelry as to a fact material to the lawfulness of the sale. You know, they go through the whole thing, all in violation of 922A6. So they're not just, they didn't just say he lied, period, you know, so says the grand jury.
No, the government tracked the language of the statute. Mr. Holden could have been prosecuted for a lie with respect to any old indictment or anything that the government could have
But
investigated.
nothing in the language I just read you limits it to 922N.
No, except the language that it has to be material to the lawfulness of the sale. That's embedded in the essential element instructions for 922A6.
I think we have your point. At least I'm satisfied. I have your
Yep.
point.
Thank you very much.
Thank you, Mr. Schmid. Mr. Holler, anything further?
Your Honor, I think the Supreme Court cases I've already cited establish that the court does not reach the constitutional question. And I think that the Supreme Court's most recent interpretation of A6, Abramski, reads that case, reads A6 mostly in paramateria with 924A1A, and does read it broadly. It says you have to tell us who is actually buying the firearm so we can figure out whether you violated a provision of the chapter. And similarly here, for all the reasons you guys have already stated, I think that applies here as well. Thank you.
Thank you very much. And Mr. Schmid, we appreciate your willingness to accept the appointment and your assistance to the court as well as your client. The case is taken under advisement. We'll hear argument now in the case of United States against Brooks. Mr. Betty.
Good morning. May it please the court. I'm Jonathan Betty, and I'm going to be speaking for Thomas Brooks today. Mr. Brooks was charged with one count of 922G. He pled guilty, he accepted responsibility, and was then sentenced to an above-guideline sentence of 96 months when he was looking at a cap of 120 months. We are here essentially for two reasons. One, the facts do not support the legal conclusion that Mr. Brooks created substantial risk of bodily harm to another when he dropped his weapon. And two, that the district court erred when justifying the over-guideline sentence by reasoning the switch on the weapon was not accounted for in the guideline. I'd like to start with the two-level enhancement of 3C12 for reckless endangerment during flight. The government needs to prove a substantial risk of death, and not just some risk or a slight risk, but a substantial risk of death or injury. The district court ruled for three reasons that the enhancement should be applied. One, that an adult or child could have found the firearm and killed themselves or someone else. Two, that the gun was thrown and it could have discharged. And three, that the police pulling their weapons out during the chase could have caused a seriously bodily injury.
So let me just pause on this. If all you were here to say is that 96 months is a pretty steep sentence for what seems to have happened here, this then 19-year-old person, I would agree with you. It's a high sentence. But on the other hand, the underlying facts are what the district court is weighing, and we review those deferentially. It's a Glock 26 with a switch. It's got 17 rounds of ammunition. There's a round loaded in the chamber. It's in a residential area. He says there are cars going back and forth. There are a lot of people around. Where's the clear error?
Your Honor, the clear error is in the application of his analysis to the facts. I'm not disputing the facts there.
But there surely is risk in this situation. You know, as it happens, the police ran up and they got the gun very quickly, but it's very near where people walk around. And I just, whether I would have ruled that way or not, I don't know why Judge Reinhardt couldn't see it that way.
Well, Your Honor, he shouldn't have seen it that way, and I don't think that there is risk. It's not just, the standard isn't that there's some risk or that there's slight risk or there's possibility of risk. It's that there's substantial risk of great bodily harm or death.
So if somebody had picked up this Glock, you know, with the load in the chamber and, you know, like a kid, an 11-year-old kid, and starts pulling the trigger, you know, I can imagine that it's a difficult situation, not to mention that also in this scenario, as he's running, the officers don't know what he's pulling out of his waistband. I guess it turns out to be an iPhone and a magazine, but they could have started firing. We see this constantly.
Well, Your Honor, I'd like to address both of those issues. First, the idea that a child or somebody else could have picked up is pure speculation and not based on anything in the record. The record is...
Well, it's based on the fact that it's in an apartment complex. It's in a place where people, presumably people of all ages, live.
Sure, but it is not possible based on the record to reach that conclusion. The testimony by the officer that the government called during sentencing testified that the entire chase from when Mr. Brooks first came out of the apartment building to when he was detained was about 15 seconds, give or take. There were officers everywhere. The weapon was on the ground for about 45 seconds, give or take. There were officers everywhere. It is an illogical conclusion that somebody in the apartment building, a child, an adult, a senior citizen, whatever it would be, would see this chase happen, see officers all over the place, and decide to go retrace the steps of the path of flight. In some cases, that might be true, but the record does not support that conclusion here. There were officers everywhere. The body camera was shown by the government at sentencing. It was clear that this was essentially a secured location. It was a secured crime scene. People are not running in and out trying to find what was dropped. The other issue that the court relied on is that the gun could have discharged when it was thrown. And the government, I believe, conflates in their argument throwing and dropping. The officer who testified did not testify that the weapon was thrown. He said it was dropped and then another object was dropped. And I would submit that there was no evidence that the weapon was particularly able to be discharged. It was never tested. The power of the trigger wasn't tested by an expert to say that this gun was more susceptible to be fired. And it wasn't any evidence that it was cocked and so that it could go off when it was dropped. And so,
How would the officers have known that as they're chasing him? I mean, sometimes it happens that you can throw a gun on the ground and it'll fire, right?
Absolutely, Your Honor. That is absolutely a possibility.
But they don't know what the situation of this gun is, do they? How can they know?
How could they know? But the government, after this was all over, could have presented some evidence at the district court to prove that. The district court just kind of assumes that without anything in the record to support that conclusion. The district court also explained that the police pulling their weapons could have caused death or seriously bodily injury. And again, the record is completely devoid of anything to substantiate that or rely on that. The officer didn't testify that he was about to shoot. He didn't testify that he even knew what he had. And I think, and I would submit to you that saying the officers are just going to shoot when they're chasing someone, I think does a disservice to that officer. He was trained, he had 9.5 years on the force. There was no evidence that he was, for lack of a better word, a trigger-happy police officer. He was doing what he was trained to do. He wasn't about to shoot. And I think the district court relied on something that was not in the record when coming to that conclusion. And
one of the facts that the court did rely on was in giving this sentence of 96 months was that nowhere, no point had the firearm itself, the fact that it had been converted to what we, in essence, would be a machine gun. And was that factual determination in error?
If I understand your question correctly, that Mr. Brooks transferred it to the switch?
Well, it puts the switch on it, and that makes it
Correct.
satisfy the definition of machine gun.
So there's no dispute that there was a switch on the weapon. There's no dispute that it was there. I don't believe that the district court found that it was Mr. Brooks who did the modification. It was just that he was in possession of it. The district court did erroneously rely on that, saying that there was no guideline to take that part of the weapon into consideration during his analysis, and I think he erred in doing that because the guideline for an automatic weapon is clearly different than a non-automatic weapon, and that's why his base offense level was what it was, because the type of weapon was incorporated into the base offense level. I see I'm coming into my time. I'd like to reserve a little bit for rebuttal.
Certainly, counsel.
Thank you.
Ms. Anderson.
May it please the court. My name is Theodora Anderson. I represent the United States. We are asking this court to affirm defendant's sentence. First, the district court did not clearly err in concluding that defendant's conduct during flight created a substantial risk of serious bodily injury to another person as required by guideline 3C 1.2. The district court's findings, first, that defendant's conduct, one, involved discarding a loaded, chambered, modified, fully automatic.
But did the district court err when it made the determination that Brooks' possession of a dangerous firearm had not been taken into account?
No, Your Honor. The district court did not err in making that comment in coming to its sentence. Under guideline 2K 2.1A4B, For a 922G offense, the base offense level is 20 when, one, the offense involves a firearm capable of receiving a large capacity magazine, or if the firearm applies under 26 United States Code 5845A, which would include a machine gun, and the definition of machine gun also includes the switch device itself, making a firearm automatic. In this case, defendant possessed a firearm that had a large capacity magazine attached to it and simultaneously possessed a second large capacity magazine and possessed a firearm that had a switch added to it to modify it to be fully automatic. Therefore, the district court was correct that defendant's possession of the Glock with a switch attached to it did not individually impact his guideline range or his base offense level in conjunction with
But
possessing.
didn't the plea agreement represent that the base offense level of under 2K was taking into account that the gun in possession was both a large capacity firearm and, the language in the plea agreement, and that it had this switch device attached? And for that reason, the government represented that the base offense level would be 20.
Yes, the plea agreement contemplated that under both options, his base offense level would be 20. And the other argument of additional machine gun and therefore posed an additional danger to the general public, to this residential area, that bullets intended for one person
But
could...
really the representation was that this has not been considered. The idea of what the switch was able to do to the Glock, to turn it in essence into an automatic, that had not been considered yet. And so for that reason, this is one of the reasons I'm justifying. He gave two facts for why he was giving this upward departure. And my question is zoning in on, does 2K not already take that into account?
Under these circumstances, based on defendant possessing based on the plain language of 2K 2.1A4B, you get to section 1, which says that you possessed a large capacity magazine. The math, the guideline, the base offense level stops there. It does not increase. He already is at a base offense level of 20. So the fact that he also possessed a second large capacity magazine, which the court goes on just after that in the transcript to say that's an additional factor that was not considered by the guideline range, the second large capacity magazine, which I think tracks his whole reasoning of what he was saying about the switch being added. So the fact that he had while having a Glock switch would trigger 2K 2.1A4B, it did not actually impact his guideline range. It was not, the calculus stayed the same. He was a base offense level of 20. And defendant's assertion, at least in the brief, that but for his possession of a switch of such a dangerous weapon, if he had just possessed a semi-automatic firearm, his base offense level would be lower, is not true because of what I have just stated. Thank you. Moving to the record supporting the court's findings regarding the reckless endangerment enhancement, as is shown in the record, the district court's findings about the danger of discarding a loaded, chambered, illegally modified, fully automatic handgun directly next to a apartment building near a sidewalk that led in and out of the apartment building and a parking lot at 12 p.m. during the middle of the day, in which you can see that the parking lot is full, that when they're there, there are people going in and out, someone comes out onto their porch. That is well grounded in the undisputed facts in the record and reasonable and common sense inferences made therefrom. The argument that because the police were able to successfully retrace the flight path of defendant, that means that the risk is non-existent. We disagree with that. Defendant is the one that created the substantial risk in the first place. Because the police were able to retrace their steps should not retroactively negate the risk that defendant himself created. And the district court made specific findings that defendant's actions were meant to hide the gun, that he saw police and he discarded the gun to hide it, and that but for the police finding it, the district court made specific findings based on the body-worn camera, the testimony, and the undisputed facts that it would have been found quickly if the police did not find it. Additionally, the court was clear on its rulings related to the use of pulling firearms by law enforcement in this residential area during the middle of the day, and the risk of an accidental discharge in this area, an occupied residential area during the middle of the day, would cause a danger of someone being shot, serious bodily injury, or death. And each of those findings, we would argue, is supported by the precedent of this court and supports the enhancement. Even if this court were to find that the district court erred in applying the enhancement, the district court did make clear that based on its rulings related to the 3553A factors, that it would have sentenced defendant to the same sentence regardless of the application of the reckless endangerment enhancement, and therefore any error would be harmless. If there are no further questions, we're asking that this court affirm defendant's sentence. Thank you.
Thank you, Ms. Anderson. Anything further, Mr. Betty?
Yes, Your Honor. Your Honor, the government states that it would be our position that discarding the gun would create a non-existent risk, and that misstates as a misunderstanding of what the enhancement is. It's a reckless endangerment during flight, and it has to be the defendant created a substantial risk of death, not some risk, not a little risk, but a substantial risk. And with all the police officers out there, with all of them doing their job, there may be some risk, there may be a little risk, but that doesn't meet the standard of substantial risk, a death of serious bodily injury. The government also talked about this being harmless error, and the guideline calculation must be done correctly. That's the starting point. That's what we have always said. It's 3553-4, I believe. And the Supreme Court and this court have affirmed that a defendant's guideline anchors the court's decision, the court's discretion in selecting an appropriate sentence, and that it must be done right. And in this case, the district court did not give an independent basis about why, if the enhancement wasn't applied, Mr. Brooks would still get the 96 months. And so this was not harmless, and it was not explained by the district court. I see my time is up. If there's no other questions, thank you.
Mm-hmm. Thank you very much. And Mr. Betty, we appreciate your willingness to accept the appointment and your assistance to the court and your client in this case. The case is taken under advisement. Ramos against Kijakazi is our next case.
Good morning, Your Honors, and may it please the court.
We let your adversary find a seat first.
Apologies for that.
Mr. Farr.
Thank you. Good morning, Your Honors, and may it please the court. I would reframe the issue here to a question of whether, or rather, how much evidence of behavioral abnormality can an ALJ ignore before it becomes harmful error, requiring reversal. In this case, Mr. Ramos filed for SSI benefits in May of 2018 and between two hospitalizations for suicide attempts. And later that year, there was some altercation with the police. The account of what exactly happened varied over time.
Can you highlight for me what you think the greatest omissions were somehow in the ALJ's consideration? Because whether I would have weighed this the same way or not, you have, Dr. Brooks, who's evaluating, it seems, all of the testimony. You have the ALJ's awareness that he's got, at best a spotty work history, pretty unsuccessful work history. the ALJ seems to be aware of the suicidal tendencies. So if you got the redo that you wanted, how would the package of evidence be expanded?
I think that would focus more actually on the 2020 forward evidence when he's back into treatment, because it establishes, for one thing, that his mental health providers, even though he's changed systems over to Indiana, still view him as having serious limitations. I know a global assessment of functioning is not an opinion, but it's still consistent with what the tropical Texas providers had thought. And that's when we start seeing more evidence of actual clinical abnormalities in the record, whereas before it's more like these big incidents that happened and then a gap of care for like a year.
What about this on-again, off-again compliance with the medications? It seems that he does get better when he is prescribed and stays on the medications, though he never seems to stay on them for too long.
So I think there's two parts to that. One, at least my reading of the record is that he stays consistently having issues with anger management and interpersonal relations, even when his depressive symptoms are more well maintained. And I think that that was a big issue that I had with Dr. Brooks's testimony, where there wasn't really an acknowledgement of these social limitations, even though there was evidence of this in the record, and this weird fixation on cognitive impairment. The other side of this is that I think it's fairly well established that people with severe mental illness, even though noncompliance does have to be considered, they do have difficulty sticking with medication regimens, more so than patients with a physical impairment.
That's because they're mentally impaired, right?
Exactly, yeah. And so I think that it's not that the judge couldn't, on a new hearing, ultimately say, you know what, there's enough here to say you're not disabled. That could be the ultimate result. But I think that there is enough evidence of these anger issues, and the judge doesn't really discuss it, and Dr. Brooks, who she's relying on, mischaracterizes what was being discussed there. So, yeah, there's those big events in 2018. I think they're important, but really I think it's more the evidence in 2020. When he's in this ongoing consistent treatment, again, he has these issues with compliance. Again, there's a history of substance use. There are definitely factors that the judge could use to say, I'm not going to find you disabled. But I think she needs to discuss the contradictory evidence to her holding as well. And I don't think that she really did that in downplaying the symptoms observed in the treatment sessions to characterize it as, I think it was something like, sometimes he seemed depressed, is basically how she phrased the evidence. To not really discuss the issues with anger or relational difficulties. And I think that forms a stronger bridge to what was happening in 2018. I also think that it's reasonable that the consultants, when they looked at this case, didn't provide as great of limitations, because they were looking at sort of late 2018 and then in 2019. And at that point in time, he'd had these big episodes. He wasn't very consistent on care, even though a lot more care had been recommended, and then he dropped out of care for like a year. So when the consultants are providing these lesser limitations, I think that's pretty well grounded for them to do so. But the picture, again, had changed by 2020. And I think that, again, is why I keep coming back to 2020. I think that's the most important thing. And again, his depression symptoms maybe are better managed when he's on medication, but he continues to have these issues with his family, with his girlfriend. There's this pattern that I know I'm kind of repeating myself now, but it links back to that 2018 pattern of, well, he's doing something to get in trouble with this police officer. He's engaging with this police officer in kind of a weird way.
So can I ask you, I know you were trying to get answers from the vocational expert, and one of the typical questions somebody will pose to a vocational expert is something along the lines of, if he would be out of work, 2 days a month or 3 days a month, would that be work preclusive? Where was that question asked?
Oh, I apologize.
I feel like it was asked somewhere.
Yes, let me look.
The number of days is interesting because, if he has these outbursts of anger where he's shouting and isn't appropriate for the workplace, I can imagine an employer might send him home.
And I don't know that I asked about absences. I asked about whether he'd have to tolerate employer interactions.
Right,
that was
you emphasize that. I mean, you
yeah.
say if he can't interact with humans,
Yeah.
then why can he interact with supervisors but not coworkers or other
Right.
visitors to the workplace? That's clearly there in the record.
I think I failed to ask a question about absences, frankly.
Okay.
It might be in there, but I don't think I did. And normally that would come up, but I also feel like the bigger issue here, and that I keep emphasizing, is these anger episodes. And so I don't necessarily think maybe if he could live in a bubble and not interact with other people, then he could show up to his job every day. And there's also this kind of weird, Mr. Ramos only disclosed to me after the hearing, oh, actually, sometimes I work at this hot dog stand. So he's doing some sort of work, sometimes, to some degree. I don't know how well he's able to stick with a schedule or anything. We weren't able to develop that further. I did update the ALJ to let her know he's disclosed this. So that certainly could be evidence of, well, you can stick to some kind of schedule if you're doing this consistently. And so that might make a problem for something like absences or time off task if he's able to work somewhat. But I do think that when it's based around, well, if the weather's all right and if I'm feeling good enough, then I'll do it, maybe that's suggesting more that a lot of the time he's not really going to be in a place where he can interact with these people regularly or even interact with the guy who actually owns the hot dog stand. So I think that probably answered that question.
Yeah, that's fine. Yeah.
I actually think probably I'd rather just reserve the remainder of my time unless there are other questions for me right now.
Certainly, Mr. Farr.
Okay, thank you.
Ms. Bechtold-Bauer.
Very good. It's a tough one. Good morning, Your Honors, and may it please the Court. Erin Brechtelsbauer on behalf of the Acting Commissioner of Social Security. I'd like to start with where my opponent ended a little bit there. As far as his anger issues and Dr. Brooks's testimony, Dr. Brooks did not mischaracterize Mr. Ramos's anger issues. In fact, he directly confronted them. He noted Mr. Ramos's reports of significant anger issues. He noted Mr. Ramos's encounter with police and the alleged harassment of a public official, of an officer back in 2018. And as counsel mentioned quite a few times, that the more recent evidence, the 2020 treatment, is what he considers the most important because it demonstrates a, quote, pattern that links back to the 2018. To me, that effectively says what we're saying. It's a pattern. It's the same thing that the ALJ considered, that the state agency physicians who opined lesser limitations than the ALJ found considered. And Dr. Brooks did consider the 2020 record, all of the medical records he considered.
But aside from in fantasy land, it's hard for me to imagine Mr. Ramos holding down a regular job. He holds up in his room all day long. He doesn't speak to his father. The only person he speaks to is his mother. He has daily outbursts of inappropriate anger, and there's never really a satisfactory answer to the question why supervisors are different from other people. And if he can't control himself around people, why is it that he can control himself around supervisors well enough to be supervised?
That's a great question, Your Honor, and I do think there is an answer to it. As the ALJ discussed, Mr. Ramos mentioned difficulties relating to his girlfriend, difficulties engaging with his parents is in the transcript. That's primarily what he talks about, right? Fighting with his parents. He's 23 years old. With all due respect,
and he says he spends all his time in his room.
Right, to avoid the fights with his parents.
So he doesn't want to be with anybody.
Right, and again, he does say he spends his time in his room so that he doesn't reach an argument with his parents. So I would argue that doesn't show.
So you're thinking there's a workplace, it's certainly not the jobs that are identified, a workplace where he's just inside a bubble and never sees anybody?
I don't think that's necessary, and I think the ALJ was reasonable in finding that was not necessary, that superficial occasional interaction with supervisors, the public, and coworkers would be sustainable for
What
Mr.
evidence
Ramos.
supported that?
Mr. Ramos' own statements that he didn't have difficulty interacting with supervisors, that he didn't lose a job because of those things. And indeed, even his hot dog stand that's a job where you're constantly working with the public.
But we don't know how many hours. We could have been there an hour a day. We could have been there 40 hours a week. That's very unsupported in the record, it seems. I mean, counsel did the right thing to call it to the ALJ's attention, but nobody ever reopens the record for more detail.
That is true, Your Honor, though it was sent to the ALJ in a letter from counsel, and so any detail he thought would support his case, it makes sense that he would include it because
This is a Step 5 case, right?
I'm sorry? Yes, this was Step 5.
The burden is on the commissioner.
I'm sorry?
The burden is therefore on the
The
commissioner.
burden to produce jobs, Your Honor, is on the commissioner. However, the burden of proving disability is always on the claimant. And if he thought his inability to work regular hours at this hot dog stand or interact with customers at this hot dog stand was something supporting his disability, which those facts probably would have helped support his case, it made sense he would include those. The letter actually from counsel, it's at, I believe, record 370, is essentially saying this might be substantial gainful activity. I don't know. So if you want to look into it for that purpose, here you are. But going back to the evidence supporting a superficial occasional interaction with others, 3 medical opinions. The only medical opinions in the record from 2 state agency psychologists who reviewed the majority of the record through 2018, and Dr.
That's
Brooks.
when he's still suicidal.
Yes, he had suicidal ideations pretty consistently throughout the record, and Dr. Brooks discusses it, and both state agency psychologists discussed both his March 2018 hospitalization and his May 2018 hospitalization, as well, and the arrest was in those records as well, and Dr. Brooks specifically mentioned the arrest. As far as the 2020 records that counsel indicated are the most important for a review on remand, he points to a total of, I believe, 4 medical appointments and 3 therapy sessions. The 3 therapy sessions are on topics that the ALJ discussed: suicidal ideation, difficulties of interaction with others. And the 4 medical appointments he points to, 2 of them have 1 abnormal finding as to his mental status exams, and the rest of the mental status exam is completely normal. And those 2 notably are the later appointments. The first 2 appointments, when he's just reinitiating treatment, are when he has more abnormal findings. But to Your Honor's point earlier, when he was on his medication, once he reestablished the care, he showed improvement. And so as far as that altering the ALJ's consideration with additional articulation as to those records, I don't see any reason that would, particularly, again, giving Dr. Brooks reviewed those records and opined that he had lesser limitations than the ALJ found. The ALJ, again, assessed the most limiting, the greatest limitations of anyone in the record. And this is not a case where an ALJ kind of skirted things or anything like that. She called not just Dr. Brooks, a testifying psychological expert, she also called a testifying medical expert as to Mr. Ramos's potential physical impairments. She went above and beyond to develop the record here, to get updated opinions on his functioning given this, additional records after the state agency review. So this is not a case where there's more to review. Could the ALJ have been more verbose? Yes, that's essentially always the case. But conciseness is not an error, and here she discussed the lines of evidence that Mr. Ramos now points to, and no more was required. The articulation bar is low, and substantial evidence is a very deferential standard. And here, 3 medical opinions and general consideration of the evidence supporting and undermining disability, we argue would meet that standard. If the court has no further questions, we would rest on our brief and ask you to affirm.
Mm-hmm.
Thank you, Your Honor.
Thank you, counsel. Anything farther, Mr. Farr?
Yes. In listening to that response, I think the biggest thing I would emphasize in reply is that Dr. Brooks is not the ALJ, and evidence that he provided to support his decision is one thing. Evidence that the ALJ actually relied upon to reach her final decision is another thing. Dr. Brooks characterized the clinical findings as largely normal. He did cite to things like the hospitalizations, as opposing counsel just discussed, but he treated the new evidence as a normal record, and that's not consistent with that evidence. Secondly, he could not outline what would cause him to provide social limitations. This was a matter of some dispute in the hearing. I repeatedly tried to get him to clarify, what would you actually need to say that somebody would have these extra social limitations? He said there were other things than cognitive impairment on a mini mental status exam, but he never outlined those things. And given that we're talking about a mental impairment, there's not a lot of objective evidence, depending on how you interpret clinical findings like depressed affect, maybe no objective evidence that can exist. But he was consistently describing these relational issues that suggest greater social limitations. even when his depressive symptoms were better controlled. So the judge had to, in her decision, if she wanted to rely on Dr. Brooks's decision, explain why his issues, why the issues with his testimony are actually still persuasive enough. How, when he's not consistent with the record and not really able to fully support how he's reaching the limitations he's provided, how is that actually persuasive opinion? And that actually sounds sort of like a 20 CFR 416.920C issue, where she's not actually maybe properly evaluating the opinion. That's not the specific issue I raised here, though. Her actual decision, then, doesn't even outline all the evidence that, say, Dr. Brooks discussed, doesn't explain fully why she found that opinion persuasive, downplays the argument issues, and suggests it's more general findings of largely normal findings in the record. I don't think that really characterizes the nature of his treatment. Again, if she discusses all these things and still says, actually, I find Dr. Brooks to be persuasive here, I believe him, and she says, actually, I think this hot dog stand work actually counteracts Ramos's own testimony on the subject, that would be one thing, but I don't think that she can fairly devalue Ramos's testimony.
United States against Quinones Figueroa. Mr. Sullivan.
Good morning, Your Honor. Checking that it's still morning. My name is John L. Sullivan. I'm here on behalf of Elias Quinones Figueroa. He was pled guilty and was sentenced by Judge Kendall in the Northern District of Illinois. I bring the case on appeal to raise issues about consistency. The guidelines were originally designed and implemented in order to bring some consistency across all kinds of parameters to federal sentencing. Like offenders doing like things with like backgrounds would get generally similar sentences. That's been modified to some degree. Now the district courts are required to correctly calculate the guidelines. They're required to consider the guidelines, but they're not required to mandatorily required to follow them. They're advisory. And so the objective now is to get consistent advice to the district court judges. In my view, the district court should be calculating the guidelines and accepting the advice as advice and considering it. But it shouldn't be wondering whether the advisory guideline, the sentencing range, was greater or lesser than it should be, whether it's over-considered or under-considered some factors. Consider the facts as to Mr. Quinones Figueroa. Carjacking, there was a gun involved, there was a threat, nobody was shot. I'm not downplaying any aspect of this case. All of that's very bad. It's a real problem. But from my point of view, the worst aspect of this case was Mr. Quinones Figueroa driving on Ogden Avenue at 68 miles an hour, running a red light and hitting a bicyclist in the intersection.
So maybe just to cut to the chase, why in imposing the enhancement, why isn't this whole reckless, 68 mile an hour careening down a busy city street in Chicago, why isn't this action, hasn't he even admitted that this is action in the course of attempting to avoid detection of responsibility for the carjacking offense? He says he sees the Chicago police car sitting there. He thinks that they're going to add up, what the license plate is on this car he's driving and some stolen vehicle report. Off he zooms, and it's all, as the guidelines put it, is all part and parcel of the original carjacking offense. Hence, this terrible thing that happened to the bicycle rider would justify the 6th level special offense characteristic enhancement.
Judge, I don't think it's part of the original offense.
It's trying to avoid, he's done the original, he's stolen the car.
No
we know
question.
that. But why isn't he trying to avoid detection of responsibility for the car theft by roaring away from the police car he sees?
It's a question, in my mind, temporally and geographically. How?
It's only 3 hours, and it's not that far
I
geographically.
understand, Judge. So, but where do you draw the line? What if it didn't happen until 3 days later? Is it still part of the carjacking?
I think you'd have to ask the question, is this done in the course of attempting to avoid detection of responsibility? That's a fact question. That's the definition
Judge,
under 1B1.3 of relevant conduct.
All flight to avoid arrest is to avoid detection or prosecution.
Yeah.
And there's a guideline that covers that. 3C 1.3, I believe, or 1.2, the other one that is involved here. So it's a question of why, when there is a specific offense characteristic that might involve injury, do you try and force the flight issue that's covered by 3C 1.3?
But it's also covered by 2B 3.1B3C. It increases the baseline for robbery by 6 levels if any victim sustained permanent or life-threatening bodily injury.
And I think you have to presume there that everybody he would ever run into for days afterwards is a victim.
If he's in the car driving it to escape a Chicago police officer.
If it happens a week later, I think there's got to be some temporal limit. It doesn't make a realistic connection to say if he's avoiding the police 2 weeks later that it's still part of the carjacking. I mean, the government argued in the district court the carjacking isn't over yet. Wait a minute, he's got it, it's in his possession, he's gone away, he's been joyriding in it. How is it still part of the carjacking? Now, I agree it's part of flight.
Are you deleting, or do you think 1B1.3 shouldn't have included in the course of attempting to avoid detection of responsibility?
I think there should be a limit on that. If you look at the...
What's your limit? Is it temporal or is it spatial?
I'll go back to Donaby, which is, I believe, a decision out of this court, 2003, where the gentleman, the 3 men took, I think it was more than 3 men, actually stole 3 cars and used 3 cars in an effort to block police from chasing them as they were fleeing the scene of a bank robbery. That flight to avoid detection, I have no question. It's immediate from the scene. They planned it. They used other cars. These other actions were clearly designed to be part of the flight and part of the original offense. And my question is, when you get to this case with Mr. Quinones-Figueroa, how far can you move it before it's no longer part of the offense? And then I get into the second part of it.
Doesn't the relevant conduct definition in the course of attempting to avoid detection answer that question for you?
But that's the same, you could say the same thing for all flight. Whether it be...
Well, and if that's what it means, that's what it means.
Well, so then...
Is there some statement by the Sentencing Commission that it has a narrower meaning than its text implies?
I haven't seen one.
No, if you look at the application notes, you don't see that
Correct.
kind of assertion.
Correct. But
well, then it's relevant conduct.
Then what do you do?
It's just a question of what the Sentencing Commission has done in fact.
But is it only that? Should it then only be considered as the specific offense characteristic?
You're making to us an argument that might be made to the Sentencing Commission to change the scope of the guideline.
I believe there's some validity to what Your Honor is saying, but I'm not. I think this court should also. I mean, the problem is that the district judge in this case said, "I'm going to interpret the guidelines as allowing me to shove the flight and hitting the bicyclist into this cubbyhole, and he gets 6 points." And then she took the second step and said, "Oh, and by the way, I think there's some other obstruction or endangerment of other people, so I'm going to give him 2 more points."
Well, that's 3C1.2, and you complain that it should have been one or the other. Of course, you'd rather it just be only 3C1.2, but 3C1.2 talks about, you know, solely doing something on the basis of the same conduct, or we've said that, and she says, well, actually, you know, even after this bicyclist goes flying off onto the street, he continues to drive in a crazy way. He spins around in the street, does a 180, crashes into a car. So there's more conduct that's certainly distinct from whatever he did to the bicyclist.
Judge, I think it's hard to parse that conduct.
Well,
That conduct occurred over 200 feet
I
with a car that's
understand.
going 68 miles an hour that hits someone. That's volitional conduct. He said,
Probably
oh, by the
happened.
way, I'm going to endanger these other people.
Yeah, he kept going.
What?
He kept going.
I don't think he had any choice. He'd hit somebody.
What
And
do you
I'm not
mean
saying
you don't
that
think
was.
he had any choice? The
No,
law
what-
required him to stop.
No, I
He had a
understand.
choice to obey the law or a choice to defy it. And there are consequences for defying your legal obligations.
Judge, there's no testimony whether or not he applied the brakes or not. You misunderstand what I said. You're talking between the time he came into the intersection and the time he hit a parked car, hit the bicyclist and hit the parked car, is a matter of 3 or 4 seconds. I'm not sure there was any thinking going on in this man's head. I don't think he was trying to get away. He tried to crawl out of the vehicle. We know that. But the district judge applied 2 more points under the flight endangerment while in flight. And she's about as I call it, clear as mud as to why. Well, he endangered other people.
Thank
There were
you,
other people
counsel.
on the street. Thank you, Your Honor.
Ms. Greenwald.
Good morning, Your Honors. Whatever he was thinking after he hit the bicyclist, he was thinking when he drove at 68 or 78 miles per hour through the first red light down a city block of mixed residential and commercial businesses on a two-way street with bike lanes on both sides. And that, I don't think we pointed that out directly in our brief, but that would be at the record at 43, page 5, sorry. He was thinking when he kept going down the second block through the second red light, and he was thinking as he approached a really commercial, busy intersection. By the way, this is all happening at rush hour, and didn't try and slow down there. And had he slowed down and stopped before there, he would have, as this court said in Swope, in noticing that if the defendant had just shot at the police officer, he just would have gotten 3A 1.2. Here, he would have just gotten 3C 1.2. But he didn't slow down, he didn't stop, and he went into that intersection and he hurt that bicyclist terribly, and that's why he got the additional 6 points. So there's a series, as this court pointed out in Swope, as other circuits have pointed out, as we've cited in our brief, flight isn't just flight, there's different acts in it. And here there were a lot of different acts, as the district court noted, and so it wasn't just based solely on what happened in that intersection. And as to the robbery enhancement, again, you know, as this court noted, there is no temporal limitation. This court pointed that out in Jones. And Donaby is controlling, and it's controlling for us, because the argument in Donaby was because that car had been stolen in preparation for the robbery. I think it was 5 days or 5 days before the robbery, it was too attenuated. And there was case law out of the First Circuit saying that. And this court said, absolutely not. Based on the plain language of the relevant conduct guideline, it was in preparation for, it helped evade afterward. And therefore, it applied. So as we cited in our brief, the law is firmly on in support of what the district court did here. Unless the court has any questions?
See none? Thank you very much.
Thank you.
The case is taken under advisement. And Mr. Sullivan, we appreciate your willingness to accept the appointment in this case. Court will be in recess.